From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening, and that means it's another edition of FLA Law on the radio. My name is Matthew Noyes, and I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the proud sponsors and the host of FLA Law on the radio. We've now been doing this, for over a year, and really we feel it's just giving back to the community to be able to answer any questions you have regarding the law free of charge. So I encourage you to utilize this hour to reach out with any legal questions that you have. You can call us at 727-441-3000, and we'll be happy to tackle any questions that you have regarding the law. You can also find us on Facebook Live on our firm Facebook page, and that's Perenich, Caulfield, Avril Noyes Injury Lawyers. And if you don't want to hear your voice on the radio, but you still have a question, we encourage you to just type in a comment with your question, and we'll be happy to address that. And I keep saying we because I'm not here alone. I have my friend and my law partner, Lori Robinson, here as well. Lori, again, thank you for coming.
Always glad to share a little time here on the radio and Tampa Bay here, see what questions we can answer.
Yeah, Lori's co-hosted with Jacqueline several times. Jacqueline Bryant and I switch off every month, and so I have not been on the radio since November. And we've been off the air for the last 2 weeks because of Christmas and New Year. So we hope everybody had a wonderful Christmas and a safe and joyous New Year. But we are here back live. Lori Robinson and Matt Noyes here, able to tackle questions that you have regarding our areas of law, but really any areas of law that you feel that you have a question about. So, Lori, before we start asking ourselves questions, why don't you tell our listeners, what are our areas of law?
Well, we, of course, specialize in all areas involving personal injury, and that covers a pretty broad cross-section of things that can happen. So
you'd be surprised at people when you say personal injury, they don't really understand what that means.
No,
how many clients have we said, "Oh, I didn't know you did all
right.
the way to the
So it seems so clear-cut to us, but anything in which you would be injured is something that might be something we could help you with. So, for example, the most obvious area, probably our largest area, would be automobile accidents, but it also could be a slip and fall in a store or some other premise that's happening as a result of someone's negligence. Likewise with the automobile, we also handle cases that involve injuries that occur as a part of your work, which would be a workers' compensation injury. We do review and handle cases involving medical malpractice, which would involve medical negligence. And we also handle quite a number of cases in the area of Social Security disability. That's going to be a situation where it's not going to involve negligence of any kind or even necessarily an accident, but it may be that as a result of certain medical conditions, which could come from any possible source, you are unable to continue to work. And in that scenario, you may be qualified for Social Security disability. And that's something that we help a lot of people with and are always happy to handle. So those are all cases. That's where I say personal injury or some aspect of your health has been impacted, what legal remedies might exist. So anything in that broad area would be something we would help people with and have been for actually the law firm is entering its 70th year.
Yes, this is the year that it's 70th. Guy Perenich started our law firm down in downtown Clearwater in the old fire station down, I think it was on Cleveland Street. Or maybe it was Court Street, but I think it was Cleveland Street. Mm-hmm. He started the law firm with Frank Muscarella, whose daughter now is a judge.
Yes.
And Guy and Frank started it with the understanding that they just wanted to do personal injury. Mm-hmm. Guy was an insurance adjuster before he became an attorney, and he said, I want to help the good guys. And so that's why he decided to start his practice. And he was one of the first to really just handle personal injury cases. And 70 years later, we're
Right.
still doing it.
Exactly. So
His
we have a
son-
lot of experience.
That's right. Mark Perenich is Guy's son. He's our partner as well.
Mm-hmm.
And so it's with Brian Caulfield, Mark Perenich, myself, Jacqueline, and Lori. It makes a pretty good team to fight the insurance companies, because they have a team of lawyers
Oh, yes.
fighting for the insurance companies. We just think it's fair that you also have a team of lawyers and great legal assistants also
Absolutely.
fighting for you against the insurance company.
And we pride ourselves on being able to give people a lot of personal attention, which some of the larger law firms you might hear, we're pretty good size, but we're small enough so that we can be quite personal in our attention to the client.
That's 100% true. The one thing I like to do the most with what the firm does is our client picnic and our client baseball game, because it's just so good to see the clients and sit there and talk to them. And some clients we hadn't seen in 10 years, and because of the personal nature, and we take our clients, we treat them like family, and we feel like they're family.
Yes.
And so it's good to see people that we haven't seen in 5 to 10 years come back and say, "Oh, glad I didn't need you. Glad I haven't seen you in 10 years."
It's kind of a long-term relationship
But
for
it
us.
is a long time. That's right. And I guess the last picnic we were at, you weren't able to go, Lori, because you were enjoying an adventure of your own.
I was in.
Why don't you tell our
I
listeners
was
about
actually on a pilgrimage in France, so it would only take something of that magnitude for me to miss our firm picnic, because they are great events. It's always really great fun to see the clients and their families and all of that. But this was, kind of one of those trips of a lifetime experiences. So I went all around France, starting at the very southwestern area at a place called Lourdes, and then we went all along the Mediterranean, up the center, eventually to Paris, and saw so many things, and it was just fascinating. And so I was very excited. I got to walk around Notre Dame, but they had still not opened it after that terrible fire about 5 years ago. But they were just about to, and so now
you had to leave a few days early.
Yeah,
right?
so I'm really, I have a burning desire to get back there now and just be able to go inside. Yeah, but I've been reading about all the history of it.
That'd be cool.
It's just very, very, very
we
cool.
were talking this morning, what in history has occurred.
Yes.
And the cathedral is still there and still standing.
Oh, it really because of course the United States, we are relatively new in the scheme of things, a couple 100+ years old. But boy, you go back to Europe and you really see the foundations that we, of course, have benefited from. But yes, it was built in 1260.
Wow.
And it's this incredible Gothic cathedral. And it went all the way through the French Revolution, and many of the terrible things that happened in the French Revolution. They didn't have quite the understanding that we had at various times. And they completely decimated. It wasn't used. It was like a warehouse for a period of time. And then it came back. And in the time of Napoleon Bonaparte, all these things I learned about in school that I really didn't remember much about, And then, of course, very movingly in World War II, when it was when the war came to an end for France, thank God, with our help, obviously, United States, not mine, but Charles de Gaulle was a famous general, and he actually marched into Paris, and they celebrated the victory in Notre Dame. So wow. It's seen so many different things in its life. So it really touched me when the fire happened, as it touched so many people, because it just has kind of an iconic status. But it was, it was built really for the glory of God, and it's quite a beautiful, beautiful structure and quite interesting. So that was the reason I couldn't make the picnic, but I won't miss another one, I hope.
Yeah, and anybody who knows Lori has been, with the firm now 27,
this will be
20.
I guess I'm entering the 26. I started in 1998. So it's
28,
26,
something like that.
Yeah, you are right.
A lot.
20, you're right. I'll be entering the 27th year. That's right. Wow, I can't believe it.
Yeah, and so anyone who knows Lori, she doesn't take a lot of time off, and so I'm so glad you're able to enjoy that.
Oh yes,
that pilgrimage.
It was very wonderful.
But I did. So if you have questions about, I guess if you have questions about Notre Dame, you can even ask about that. Even the Fighting Irish, the football
That's
game
right.
that's going to be happening soon too, you can ask about that.
Yes, I guess they've done pretty well.
Yes, they're still in it. I would need my son here to answer some of those questions if you call about the Notre Dame football. But if you have questions regarding personal injury, auto accidents, car insurance, slip and falls, trip and falls, workers' comp claims, what your rights are, but also what your responsibilities are, because I think it's not fair if all we talk about are what your rights are and we don't talk about what you got to do too. Mm-hmm. And also Social Security disability. Lori and I pride ourselves in really fighting for people for Social Security disability. These people have worked most of their lives, and from no fault of their own, they have conditions, whether it's a physical condition or a mental condition, that prevents them from being able to return to the workforce. And so they put into the system for so long that they have a right to try to get their Social Security disability benefits. It's not an easy process.
No,
it's a long process.
Right.
Why don't you tell our listeners, in a nutshell, what the process is?
Yeah. So it's you ask a lawyer to say something in a nutshell. Well, I can go on.
It's a large nut.
Right. But it is, it's a process in theory a person could do on their own. But honestly, having practice for so many years, there's so many rules and regulations. It makes your mind spin. But essentially, the process in the usual situation is going to take somewhere between 18 months to 2 years at this point.
Right.
So you file an application, and of course, what's happening is you are unable to work because of a medical condition or mental combination. And you're trying to get your Social Security retirement early because that condition is preventing you from working out your normal period of time. So you file the application. We help people with that all the time. Typically, Social Security reviews it in a very bureaucratic way and takes a very long time. Now, I don't know.
It means they don't look at it.
Well, and
that's the
and they're a part of this whole thing with the big debate about whether workers come back to the office or something. And I think President Biden, in one of his parting gestures, has protected them supposedly. I don't know what that'll mean, but our personal experience in terms of what takes a very long time is the processing of these applications, and it does take, and it always, frankly, has, even when people were showing up to the office. But it has taken many months, maybe a year for the first review. Then it's typically denied, and then most of them are. And then we ask for.
I think the stat was like 87% were denied.
Is it now?
First application.
I know it's very high.
Right about there.
Yeah, and then the second one, reconsideration, different set of eyes, but the same kind of review, usually denied there. And then you can request a hearing before an administrative law judge, and that now they are scheduling those quite promptly. So once you get to that point, it might be 6 or 8 months from that request that you could get a hearing. And I will have to say the remote system works very well for that. It's a hearing. Usually, are we doing it by video? That's what they prefer. And I'm very comfortable with it, too. We can do the hearing right out of our office, conference room. It's very easy on the client. And it's a video, so you are having personal contact. Right. So the judge sees you. It's not just like a telephone hearing, which I've never been a fan of that. Right. But it works pretty well.
And the judge could be any place in the United States.
Right.
And I think that's why they are able to schedule them quicker.
Yes, that's probably true, because they certainly can get help from judges outside of our area, which does happen. And it also has allowed us actually to take cases. Sometimes we'll have a client of the firm or somebody that has been recommended to us by one of our clients, which is probably our primary source of referrals, those people that we've helped before, and they maybe moved to another area of the country. And I would normally have had to, and did over the years, you would just transfer the case and they'd have to find an attorney in that other location. You don't have to do that now. Right. Because the video hearings can be done from anywhere. So that's really been a very positive thing, actually, that part.
I think that's great. I think that's really an opportunity to best serve the client.
Yes.
And we like to bring the client in to our office. I guess technically they could do it from Zoom from their home, but we like that personal touch of bringing them in and talking with you beforehand. Yeah, because a part of the reason to have a lawyer is to have the help of a lawyer, and so I do like to meet with the individual in person if possible. But there are situations where You
It
can't
isn't.
do it.
We're just
Right.
not practical. And so we will then work with them to be sure that they have an understanding and a setup doing dry runs so that they can appear through the Zoom, and actually it's Microsoft Teams for Social Security, but so that they can handle that. So we do a practice. I've had that happen, and we do a little practice sessions beforehand.
Sure.
But it's still ideal if you can come into the office. I prefer that, and most of the clients prefer that too. But there can be situations where that won't work, and the video does allow a lot of flexibility that we did not used to have.
Right. And does the judge always render their opinion right at that hearing?
Very rarely, very rarely. You know, they'll never tell you that they're denying the benefits. Sometimes they will tell you that they're going to grant them, but not usually. Usually they will say, thank you very much. I'm going to take this under consideration. And then you have to wait another 30 days to 3 months typically now to get a written decision. But it's pretty efficient, really. I mean,
Right.
you know, when we first started doing Social Security cases 20 some odd years or more ago now, probably, it was routine for it to take 3 years. The process was much more bogged down. So there was an increase in staffing some years ago to improve that situation. Now, of course, I'm talking about an improvement, and the person who's in need of the benefits is thinking, you mean I got to wait a year, 2 years, you know? And that's probably one of the most important things that we explain to people. Many people will be thinking about whether they should apply. They're still working, but they're having a very hard time. And we will very often have a kind of a courtesy phone consult or in the office if they wanted to talk about how the process works so that you can plan, because you have to, you know, you can't count on you're going to get the benefits tomorrow or a month or a year or 6 months. You have to be basically planning for the worst case scenario, which is the most likely scenario. Now, sometimes there can be approvals earlier. We do have that happen. And obviously we're trying to get that to happen. But in the usual case, you've got to be prepared for a much longer process.
Right. We like to be able to answer any questions that the clients have at an intake. But one of the questions that we're never able to ask is, Matt, Lori, how am I supposed to survive if I'm not working and I have to wait 12 to 24 months in order to get the benefits? And there's no easy answer for that.
No, that's, you know, it's going to be personal to each person's situation. And in most instances, it's going to be a tough situation, you know, really. But that's, you do have to make plans to deal with that situation. The other thing that happens is, you know, people lose their insurance. Well, how am I supposed to get medical treatment?
That's true. Yeah.
And you absolutely have to. And there is treatment available through the county health department system. All of that requires a lot of persistence. But if you don't have insurance, there are ways to get treatment. It's not easy, though. You do have to be persistent. But in order to be approved by Social Security, you're going to have a medical record that documents the limitations you have that are preventing you from being able to work. So often people will call and they'll have a list of all of their medical diagnoses, which of course you have to have a condition that is causing you a problem to even think about applying. But the real issue is, what limitations are you experiencing because of those conditions? What is preventing you from doing your past work? And then the rules, they get a little easier as you get older, above 50. But the easiest way to think about it is, you know, what is preventing you from doing even the simplest job you could imagine? Because that's typically what Social Security is looking at. And it's absolutely for anybody under 50 works that way. As I say, but there's so many little nuances to all of this that, so if you're above 50, a little bit easier, above 55, easier yet for all these different reasons. So it is something that most people will need some legal assistance on. Right.
I agree 100%. You should not try that. Try it yourself. But if you have questions, listeners, that's why Lori and I are here. We are here to answer your questions. That's Social Security disability we've been talking about, but we also have knowledge in auto accidents, where we're going to talk about soon. And we're going to also talk about a new law having to do with trip and fall and slip and fall cases, but also work comp injuries, if you have questions regarding that. I'm Matthew Noyes. Lori Robinson is here as well. We're both attorneys at the law firm of Perenich, Caulfield, Avril Noyes. We are the longest established personal injury law firm in Tampa Bay. We are celebrating year 70 in 2025. So you'll hear that for the rest of the year, I think, because we're proud to be the oldest personal injury law firm, in Tampa Bay. So give us a call at 727-441-3000 or send us a comment on our Facebook Live at Perenich, Caulfield, Avril Noyes Injury Lawyers. We're here until 6 o'clock, and so this is the time to get your legal question answered. Lloyd, I kind of teased a little bit about the new change of law. I think it was last year. Maybe it was the year before. They all kind of run together now.
They do kind of, don't they? Really?
But could you explain to our listeners what we had to prove in a negligence claim on a trip and fall as it relates to comparative negligence in the past?
Right.
And then what law changed and how the law really impacts a trip and fall case.
Very much so. So, most people will have the sense that if you go to or you're in a store or you're on some property or whatever and you trip and fall and let's say it's an uneven pavement in the parking lot or something, or a pothole or something like that, and you're in a parking lot of a commercial establishment and you trip and you fall and you hope you're going to be okay, but turns out maybe you've really hurt your knee badly or your back or something is an ongoing issue. So you think, well, this doesn't seem right. They didn't really maintain that parking lot like they should have. Well, it used to be, so several things changed, across the board, which applied to all kinds of personal injury matters. The law changed, so where you used to have 4 years to bring a claim, they reduced that to 2,
right? Which
is significant because, now it's always been better to try to, if you've got a significant issue going on, to go see the lawyer and review that. So that probably is a good thing for people. But
except for if you had surgery and you're still recovering, you don't know what your prognosis is after 2 years. Yeah. Most of the time you do, but in some cases you just don't.
But it does mean that if you've had something occur, it does need to be evaluated reasonably quickly.
Sure.
But then the other more significant thing in a way that impacts people is that in the law there's a concept called comparative negligence. So in that example of the pothole or whatever, a jury, if you go all the way to a jury trial, they're going to have a right, and they'll be asked actually to try to proportion, if they can, the percentage of negligence that would be attributable to the defendant, so in this case, the owner of that property, of the parking lot, but also to the plaintiff who tripped. Could they have avoided that if they had been paying a little more attention?
Right.
And so a jury could be asked to, and would be asked to apportion it by percentage. What percentage is the person who is injured responsible negligent for their own negligence versus the establishment? Yeah. And so maybe they'd say 10% for the person, 90% for the owner of the property in that situation. Okay, that's pretty much the same. But it used to be that whatever that percentage is, so let's say it's 60%, the jury says, no, I think you could have done better. But the establishment was clearly negligent, 40%. Yeah. Well, in that scenario, and how the law has changed now, if you are found to be more than 50% responsible, there is no liability whatsoever.
Which is crazy, because prior to the law, if the jury says, okay, business owner, you're 50% responsible for the damages, and plaintiff, you're 50% responsible, we may not agree, but we have to go follow the jury. And then the business owner would have to pay 50% of the damages, because they caused 50% of the damages.
That's right.
Or if it was 10% the client's fault and 90% the business owner's, the business owner only had to pay 90% of the damages. I can appreciate that.
Right.
We only want the at-fault person to pay what they're responsible for. But this law changed. Now they say, okay, if it's 50-50, business owner, you don't have to pay a penny.
Not at all. And so you could have a significant amount of responsibility, as the business owner. So say the example of the parking lot that is in very bad repair, and let's say that it's in an area, it's kind of shaded. So honestly, it's not that obvious to a person that's just coming onto the lots.
Sure.
So the circumstances are such that significant negligence on the part of that property owner, no responsibility whatsoever, even for what a jury has apportioned as their responsibility.
Right.
If it's the 50% mark.
The jury said that they were 50% at fault. They should be responsible for 50% of the damages.
Right.
However, the new law says, nah, we don't think so.
No, so they've modified that concept of comparative negligence that has been around for all the time I've been practicing law, and it's and long before, I think, really. So, I mean, there used to be a very harsh rule that if there was any responsibility on the part of the injured party. No,
I think there's still some states that have that.
Yes, yeah,
which is crazy.
Right. I mean, that was so harsh that states like Florida, a long, long time ago, adopted the comparative negligence, which does seem equitable. I mean, that's an equitable way to handle it. And the laws used to kind of have I won't get into the joint and several responsibility because it's been changed for so many years, but when they ended up saying, look, you just pay your percentage that you're responsible, that seems to be a just way to address it. So the rationale behind this change is hard to follow. I mean, I really don't see that as a just change, but we have to deal with whatever
it is right now.
Yeah.
And it's not just in premise liability cases or slip and fall cases. It can play a role in an auto case
Any
too.
type of negligence.
He said, she said kind of thing. I had the red light. No, you had the red light.
Mm-hmm.
And if there's no proof one way or the other and the jury decides it's 50-50, well, the injured person gets zero.
Right.
So it's not just the premise liability cases, but it's also runs in auto accidents and
anything in which there's an apportionment of negligence, between the injured party and the responsible party. I'm going to say the defendant. Now, I will say, as a caveat to everybody that might be listening to this, don't decide on your own what that ends up meaning, because
100% true.
Right. Because, a person could hear this and say, well, what's the point? I mean, actually, I think I did have some level of responsibility. And you really, the way that these things are viewed are in a legal setting are very different than what an individual would be able to appreciate. So again, it's something that you want to talk to an attorney about. And these types of matters like Social Security, disability, any of these attorneys handle them on a contingency fee basis. There's no fee whatsoever unless there's a recovery, and then it's a percentage, and those are things that are discussed at the time of an intake appointment.
Right. So if you have a legal question, it makes sense, especially in a personal injury arena, always talk to an attorney. Of course, we want you to call us, but if you don't call us, talk to another attorney. They'll give you advice. Don't look up on Google and find out what the answer is supposed to be. An attorney will take time to talk to you, or they should take time to talk to you. I know Lori does it a lot, and our firm does it also. Sometimes we just talk to the client to answer the questions that they have, and it's not going to be a case. Right. They don't get billed for that, but they get their answers. And that's kind of how this radio show started to be born as well, is because we decided that, sometimes people have questions after 5 o'clock. And so if they have questions, they want to have a lawyer that's available.
Well, and we take calls at all hours. And occasionally that's been, rotated through the attorneys, and we have an answering service that'll handle after hours and get one of us, if there's something that's really urgent. But people have all kinds of questions, and that's okay. We're here to answer them.
That's right. Especially here on Tuesday, here on FLA Law on the radio. Again, if you have questions, our telephone number, we are live, and it is 441-3000. And if you want to jump on the Facebook Live page at Perenich, Caulfield, Avril Noyes, you can see us doing the radio show, and you can also even type in the questions that you may have if you don't want your voice or your question on the radio. But that's what we're here. I mean, we used to do a long time ago, since we are 70 years old, a long time ago, we used to have a TV show. And the TV show was FLA Law. Yes. And it was similar to our radio show, but we had attorneys come in from other areas, practice areas, and on TV.
was a lot of fun.
And answer questions and live answer questions. And that was a lot of fun to do, too. We have a lot of stories to talk about.
Oh, my goodness, yes.
But I'll date how long it's been because we used to be on Channel 9 on Bright House.
Wow.
And
that was before my time even.
that is before that's before Bay News 9 was even around. And so we were on Channel 9. We did it 3 nights a week, quite honestly. And so we did 2 up in Pinellas and 1 up in Pasco. And it was a lot of fun. We have some stories to share. I know you had a story about Lou Quall, who used to be.
I was just thinking about that.
You know, he used to be on our show all the time because him and our other partner, Bob Carroll, are neighbors and good friends.
Yeah.
So what's your story about Lou Quall?
Well, it's perfect.
Rest in peace, because he recently passed away.
Yeah. Very, very fine man. I was thinking about that because one of the mascots here at WTAN is a wonderful little Labradoodle that belongs to
He keeps looking at the door here.
Right, and very cute. So it was making me think of my favorite FLA law program was when I was fairly involved with the SPCA many years ago. So we did a program where we could bring all the dogs on. Yeah, actually, we did a couple because I think Lou's dog, Howie, who was a Cocker Spaniel, came on probably more than once. I mean, Howie was...
Oh, yes, he did.
Yeah, he was on a lot. But I liked, of course, he was very cute. But we also had we did a program for the upcoming Paws on Parade type thing or paw that they used to have and still have, I think, probably. But yeah, and we had quite a number. Howie was on that show, too. And my Dixie... that would have been Maggie, actually. I had a buff cocker Maggie. This is going way back. I used to have a buff cocker, now Dixie D. You know, actually, many of because several people from the firm brought their dogs on. It was this would not have been your favorite event necessarily.
I was not on that show,
but I loved it. Yeah, because we did. I mean, it was one that I was able to host. I think that particular one, and it was a hoot. And the dogs were very well behaved, actually. You know?
That must not have been the episode where Howie bit off the tassels of Bob Carroll's shoes.
No, it wasn't that
during the TV show. But we also did Paws on Parade. We did bowling. Remember that?
Oh, yes.
Seminole bowling.
That's right. Right.
Ago.
That was a lot of fun.
That's what happens when we're here for so long. We get to enjoy those fun things.
Oh, yeah.
But, not only do we enjoy doing those things, we really do enjoy, fighting for people.
Yes.
And when something wrong happens to them, I always say that we meet a lot of good people after bad things happen to them. And I think it's important that we make sure that they know we care, that they're not a number. I always try to say I don't have any files. I just have cases, or I just have clients because there's no files, we're here to be the voice really of people that get injured, whether it is an auto accident or other types of injuries, when it's not their fault,
right.
and their life is changed. They have a new normal is what we often try to explain to the jury, that because somebody wasn't paying attention, that this other person must adjust their life. Now, it doesn't necessarily have to be 100% adjustment, and they're bedridden and they can't feed themselves and such like that. Now, those are horrific accidents, and we do help a lot of people in those sad cases. But also the father who can't ride the roller coasters with his children, or the mother who has difficulty, picking up her children. All those things that never would be a problem now are a problem because of an injury.
Right.
And so it's important that we be the voice. So the insurance company tries to understand what they're going through. And so, Lord, how do we do that? What do we gather? It's impossible because insurance companies always see them as a pile of medical records.
Right. Yeah. That is a case or a claim to the insurance company. But of course, our role is to take something that is a claim to the insurance company and make them aware of the individual as a person whose life has been impacted. And ultimately, in preparing the claim for the insurance company, we're really trying to get them to appreciate, whoever the insurance adjuster is on the file, what would happen if we have to take this case all the way to a jury trial. because that's ultimately what they're looking at. They're not trying to figure out what's fair for the person. And that's so hard on people. They don't realize it, but the system isn't set up that way. It is adversarial. And that's why you need lawyers, because and it's a benefit in the long run, because there's no book you can go to. I mean, if it's a system that's just based on percentages and things like that, you have your workers' comp system. That's an administrative system, and it does not really compensate people at all to speak of. It's very limited to the medical and very limited wage loss. But if you are injured in an auto accident, that's subject to our tort law, which is tort dealing with injury, personal injury.
Oh, I was thinking bakery.
Yeah. Yes, right. This time of year, actually, yes, especially having been to France and all those wonderful French pastries. I'm definitely thinking bakery, but
sorry, I got you off.
but it is, so it's in that situation, the law has, the law we inherited, the common law from England, the law has always recognized that there are certain types of damages people experience. And one of them is pain and suffering. And that, can sometimes be made fun of by people, but you don't make fun of it if you are personally experiencing it.
Right.
And some of the things you can't see, like, and anyone that's really been injured in that, where they have even what's called a simple whiplash injury, it's horrible.
Right.
It's actually worse than many things because there's not a lot that can be done. Now, hopefully you can heal up. Fantastic. A lot of people do. But unfortunately, depending on the nature of the accident and the particulars of your particular body, you might not. And if you're left with some residual pain that you have to deal with that does impact, like you're saying, how you're able to enjoy your life, those are things that the common law that we have inherited recognizes as things that should be compensable. Much as we hate insurance, it does provide the ability to get compensation for injuries that a person has sustained. And so to put the case together, you have to investigate the circumstance of the accident, like we were talking about earlier, about the negligence and doing investigation to be able to prove the other party was at fault. Yeah. And then the medical damages is probably the longest part of it, because you have to see how you're going to do.
Right.
You have to treat medically and get to a point where it's kind of clear what your situation is. And medically, that's usually referred to as maximum medical improvement. When you reach a point that and typically, if you have an injury where you recover 100% within a month, great. That's the best case scenario.
Right.
So then your damages are going to be limited to your out-of-pockets.
I was going to ask you that. Do everybody who gets injured automatically get damages for pain and suffering and mental anguish?
Not in an auto case.
Right.
So in the auto case, we've added to the common law certain laws that have been passed, and we have a no-fault law. And what that means is that if it's a relatively minor accident under the way the law looks at it, which does not involve a permanent injury, then your damages are limited to your out-of-pockets, your medical expenses, your, that kind of thing, and any wage loss, no pain and suffering whatsoever, which doesn't mean you don't have it. You might have a pretty bad injury and it might take you some months, but you do recover and you have no residual permanent injury. In that situation, you just have to say, well, it seems unfair. I can't be compensated for what I've gone through, but I sure am glad that I'm all better.
Right.
Okay, that's great.
I remember having a discussion with a client that I think it was probably a year of, just hell.
Mm-hmm.
He was hurting. He was in pain. He was getting the proper medical care.
Mm-hmm.
And but his work was affected. He couldn't really, he went to work because he had to pay his bills,
Mm-hmm.
but he was just in pain for 12 months. But fortunately, on the 13th month, he was at maximum medical improvement, and the doctor said, well, we don't think he has a permanent injury. And so we had to have that discussion with him that saying, they say you don't have a permanent injury. You tell us it was hell for 12 months, but now you feel like you reached your baseline. The law says you're not entitled to pain and suffering for those 12 months, even though it was as bad as it was. And that's hard for people to understand. But it's also, important for the general public to understand that just because you get hurt, not everybody gets pain and suffering, not everybody gets mental anguish, or not trying to manipulate a system to win the lotto, so to speak. Many, if not most, if not all, would much rather not be in the system.
Right.
They much rather just live their life. An analogy that I often try to talk about is when you have a pebble in your shoe. You're walking around and it's just annoying. It's just, I mean, it's not stopping you from doing what you have to do, but it's just annoying. It's just annoying. Well, fortunately, if it's a pebble in your shoe, you could take your shoe off and take the pebble out. But when you get hurt and you have a whiplash injury and the ligaments are stretched or even torn, and so that blocks the flow of blood to your head and to your neck and to all your muscles, you can't take that out. You know, that's permanent, and you have to learn to adjust with that pebble in your neck, so to speak, you know. And so it's just, it kind of annoys me sometimes that people think that, people that get whiplash are just trying to manipulate the system when it's so far from the truth.
Yeah, I would say many, many years ago, I really just had a crook in my neck, but it was really bad, and I just slept wrong or something. And I finally went to the doctor, and I was actually diagnosed with cervical sprain, which is really what a whiplash is. Now, I have never had anything that hurt me anymore, and I've been very fortunate, I grant you. But it was very painful, and I had to take the anti-inflammatories, which are horrible and all that. But in 2 weeks, it was gone.
Right.
Okay. But because I did personal injury, I never forgot this. Because I thought, wow, this is what my clients are going through. But the difference is you can have a situation where, unfortunately, what you've just described, there is enough injury to those small fibers that you don't get back to 100%. And and you have something that can flare up in the future, you know, that type of thing. And if that's so you can have one scenario where you really are fine, and that's great. But you can have other scenarios where, unfortunately, you're not fine. And people will find that they have these flare-ups. And then sometimes people won't realize, they'll think, well, it's nothing. It's not that much. Well, if you don't get to the point where that doctor is saying to you, and you're agreeing that you're 100%, then, you know, if you have you can have a residual permanent injury that is not like, you know,
missing an arm or
right. It doesn't have to be something of that nature. I mean, if you have chronic pain issues that you have to deal with as a result of an injury that occurred, that's a recognizable permanent injury if a doctor says that it is permanent. I mean, obviously, you treat to the point you hope that you could get back to 100%. But if you don't, and the doctor agrees, I'm sorry, we've done what we can do. Now we can you can treat as needed, but we can't really improve your situation. You know, that is something that the law does recognize is a reasonable damage that you should be able to recover from a party that caused it, basically. You know, so and the limitations of the system are designed to try to be realistic about the whole insurance system, which has a lot of problems with it. You know, but people do not realize, if you've gone through an injury, I mean, how many times have we over the years represented insurance adjusters who did not appreciate, you know, when they were handling claims, it is different. You're not going to think of it that way. And you just don't even believe the person because you can't really see it. Right. You know, you don't see it. And the person may look fine. They may actually put on a good face and you have no idea, you know, but then, and a lot of times, you know, if you're in an accident, even friends I've had maybe that, you know, you can cause an accident without being a bad person. I mean, you know, you just lose attention or something. It happens to all of us. But if God forbid it does cause injury to someone and it's ends up being permanent, that's what the automobile insurance is for, basically.
You want to be accountable and responsible for your actions. You know. And that's why you buy insurance.
And a lot of times they'll be in an accident and they'll see the person that is now claiming injury. So, well, I saw them, they seem fine. Right. Well, now I'm not going to say there's no one that exaggerates. I don't know that. I mean, we do not represent people that we think are not telling the truth, obviously. You know, so, but more likely the situation is these things are not necessarily visible. I mean, if you bleed, that's visible. But this type of an injury where you're whipped around in the car, causing a whiplash strain type of an injury to the neck or the back. That's not going to be visible. And it's also
a lot of times right at the accident scene, the adrenaline is flowing. You don't have that pain. I just talked to somebody today that got in the accident this afternoon and said, my back hurts, but it's not horrible.
Right.
And I said, well, just mark it, document it, make sure you know, because typically it's about 24 hours, 36 hours after the impact, when the adrenaline slows down, when all the worry about what am I supposed to do with my car? I'm supposed to do this. Well, I'm supposed to go there. Now, how am I going to do that? When all that settles down, then your injuries manifest themselves. And
the other thing is just the way the body works, which anyone of any age knows that if younger people won't know this, but I mean, but they would maybe working out at the gym. The way your body works, the pain receptors or whatever it is, you don't really feel the pain. If you could have some acute, horrible pain, but you may not. You may not have any real sense of significant pain for a day or two.
Right.
Not just adrenaline, which adrenaline, particularly in the accident scene, does mask a lot of that, but just how the body works.
Well, I know. Well, Jacob, my son, pitches. He's a left-handed pitcher, and he's back on the mound.
Yeah.
And he's throwing 90 pitches. He feels fine.
Right.
A day later, 2 days later, it's like, oh, my shoulder hurts.
And I wonder what caused that.
I know.
And it's right.
It's like, son, that was from 2 days ago,
Yes.
So.
And so that, right. So, I mean, so those things are the other thing that a person should realize, that if you're in an accident, if you feel fine, you don't necessarily have to address it right away. But the thing is, be sure that's really the case.
Right.
The law does require that you get to the doctor, within 14 days.
What happens if you wait 15?
If you're on that 15th day, then you will not have the benefit of the automobile PIP insurance that you pay a premium for.
Right. You pay that insurance to pay for your medical and your lost wages up to $10,000.
That's right.
If you wait 15th day, if you're like stubborn like me, and you say, I'm just going to suck it up and I have too much to do, and you wait 15 days, you don't get your PIP benefits even though you paid for it.
Right. And so
you still have a claim against the at-fault driver. Right. Some people think, I waited 15 days, I don't have a claim anymore. No, you still have a claim. You just can't submit your bills to your auto insurance under your no-fault policy.
Which, if you have health insurance, okay, but you may have deductibles, things like that. Right. So it really is advisable, if you've been in any kind of a significant accident, you should get checked out right away, really. Right. But you definitely should, if you have any pain really, honestly,
any pain,
you really should. Absolutely.
It could be a walk-in clinic, it could be a chiropractor.
Just something.
You don't have to go to the ER.
Right.
You don't have to go to the ER.
No one wants to go there, of course, unless it's a true emergency.
That's what the E stands for. If it's an emergency. We have too many clients that go to the ER and they run a CAT scan, and the CAT scan at the ER is $17,000 for a CAT scan, when if they went to a CAT scan recommended by their doctor would be a few hundreds or $1,000 or something like that.
Yeah, because they're going to run every test in the world, potentially, and now you're going to exhaust all of your auto insurance money under that PIP.
Right. We're talking auto insurance, and I always say I can't go one Tuesday evening here on FLA Law on the radio without talking about the most important auto insurance
that no one knows about until they've gone through an experience,
exactly
a bad experience.
True. Yeah, and that's uninsured motorist coverage.
Yes.
Uninsured motorist coverage is the most important insurance coverage. Why is that, Lori? Because
so many people that get into accidents do not have insurance coverage or do not have very much of it. And so if you get into an automobile accident and you have a significant injury, and the person and I'll just say the person rear-ended you, okay, so no question about fault at all. And, first you think you're going to be okay, but then unfortunately a couple of days go by and you are in very, very bad pain. You finally get to the doctor, you're treating, and then you go to the lawyer, and the lawyer checks out the insurance coverage, and the person that hit you has no bodily injury liability coverage, or maybe they have $10,000, very small amount. In that scenario, there is no your claim is against the person that caused the accident.
Are they breaking the law if they don't have bodily injury liability coverage?
Because they will have, how often do we hear people say, well, I have full coverage. Well, full coverage really is $10,000 property damage, and the PIP, that medical coverage for your bills up to $10,000. So that's full coverage. So if a person, that means nothing.
Nothing.
Yeah, you really,
we hear that way too much.
Yeah, no, and people just don't understand. I don't blame them. I mean,
that's what they told me. I had full coverage.
Right. And then, when you go through like an insurance agency, you're probably, they're just selling you whatever. Right. They don't have a reason to really go into great detail, and they'll sell you what you ask for.
Right.
But this uninsured motorist, very important coverage. It's so important. The law actually requires you to sign a statement saying you understand you're waiving your right to it, because they have to offer it and give it to you. Unless you waive that right.
Right. And what happens if you do have uninsured motorist coverage and you have significant injuries, and the person that caused the accident doesn't have bodily injury liability coverage?
Now, your insurance company will essentially almost take on the place of that driver that was at fault. And if you're able to establish negligence of that driver and your damages, your insurance company will pay up to the policy limit, whatever that is, depending on the amount of damages that have been established. So if it's a settlement, you'd settle to a certain amount. But if you went all the way to a jury trial, say you have $100,000 in coverage under your uninsured motorist and your damages are $100,000 or more, you're going to have that insurance coverage that will pay those damages to you because you had that policy. Whereas if you did not, and that driver had $10,000 or no liability coverage, you'd have no recourse.
Right.
Unless the person has assets, and if a person has actual assets, but that's very rare that there's a situation where you can sue someone and they have assets you could actually recover a judgment against.
Right, because if they had assets, they would be smart enough to have bodily injury liability
to protect
coverage.
their assets.
Now, one thing that I think it puts some clients' mind at peace is that if their uninsured motorist or underinsured motorist coverage pays, their insurance company has a right to go after the at-fault driver to hold them responsible.
Sure.
And sometimes our clients say, why is my insurance company having to pay and the at-fault driver doesn't have to? Well, if the insurance company decides to bring a claim against the at-fault driver, they're able to bring the claim against the at-fault driver.
Yes.
You much rather have your insurance company going against the at-fault driver as opposed to you trying to go against the at-fault driver.
Because in that scenario, the at-fault driver probably does nothing there.
So uninsured motorist coverage is the most important coverage to have. Check your policy today to see if you have uninsured motorist coverage. Don't think that you have full coverage and think that you have it. It's too important to just not look at, because too many times people look at it after it's too late.
Yeah, we see that all the time.
Lori, we're about to wrap up.
Okay.
Thank you very much, Lori. Lori, if people have questions that's not on Tuesday between 5 and 6 o'clock, how can they reach you, me, or anybody
at our firm? Call the firm, 727-796-8282, or check us out on the internet at usalaw.com or voiceoftheinjured.com.
That's right. We are there to answer your questions. We have someone answering the questions, answering the phones 24 hours a day. Mm-hmm. So feel free to give us a call at 727-796-8282. We're wrapping up this week of FLA Law on the Radio. I will be back next week with a surprise guest. Who knows? It may be Lori again, but we'll see. But in the meantime, we always hope that you drive safely and watch out for those who don't. Take care. Good night.
And Happy New Year.